All right, let's get right into it. Welcome to today's Explainer, where we're tackling a really massive challenge facing global companies in 2026. How exactly do you deploy your absolute best talent to Spain without accidentally triggering a catastrophic tax audit? We're seeing this fascinating modern clash right now. On one side, you have the incredible flexibility of remote work, and on the other, the rigid, unyielding realities of national legal jurisdictions. It's a complex puzzle, and the stakes for getting it wrong are incredibly high. To get through this, here's our roadmap. 1. The cross-border compliance trap. 2. The A1 certificate lifeline. 3. The 49.99% telework rule. 4. Navigating non-EU bottlenecks. 5. The direct registration fallback. And finally, 6. Essential timelines and costs. Okay, let's dive in. Section 1. The cross-border compliance trap. Let's set the scene here and look at the default threat. Imagine your top employee decides they're tired of the winter. They pack up their laptop, move to a sunny cafe in Madrid, and just keep doing their job. Sounds amazing, right? But here's the million-dollar question, the core legal dilemma for HR teams today. When they make that move, who actually gets their social tax? Is it your home country where the company is headquartered, or is it Spain? Well, the answer comes down to this foundational rule, lex loci laboris. It's a fancy Latin phrase, but it literally just means the law of the place of work. It dictates that Social Security has to be paid exactly where the work is physically performed. So, by default, the second your employee connects to the Wi-Fi in Spain and starts working, boom, you have immediate Spanish Social Security liability. That is, unless you actively secure an exception. Which brings us to Section 2, the A1 certificate lifeline. How do we actually get that exception? If you're operating within the European Union, your lifeline is the portable document A1, and the critical number you need to burn into your memory here is 24. Under standard posting rules, specifically Article 12, 24 months is the absolute maximum duration allowed for a standard posted worker assignment. Think of it as a golden ticket. It lets your employee temporarily work in Spain while staying completely locked into your home country's social security system. But, and this is a huge but, you have to meet these conditions, and they are cumulative. You've got to hit every single one. First, there has to be a genuine, continuous employment relationship. Second, the worker must have had pre-existing coverage in your home country for at least a month prior to the move. Third, the duration has to be visibly under that 24-month mark. And fourth, you absolutely cannot just swap one worker out for another when their time expires. If you miss even one of these, no A1 certificate for you, and hello, Spanish taxes. Moving on to Section 3, the 49.99% telework rule. Now, that classic Article 12 we just talked about, that was built for physical deployments, like sending an engineer to a construction site. But what about digital remote workers? Enter the new EU Framework Agreement on Cross-Border Telework, and its absolute magic number, 49.99%. Under this new multilateral framework, an employee can legally telework from their residence in Spain for up to 49.99% of their total working time and still stay in their employer's home social security system. But if you cross that line to exactly 50%, the exception vanishes. Let's put these two distinct EU pathways side by side to really see the trade-offs. Standard posting is all about physical deployment to a site, capped at 24 months. Cross-border telework, on the other hand, is strictly about a hybrid remote IT connection. It's capped at just under 50% of their time, but it can actually be certified for up to 3 years. They're two completely different legal tools built for totally different modern schedules. Now, here's a fascinating quirk that mobility experts call the Baltic catch. This 49.99% telework rule, it is an opt-in treaty. It only works if both the home state and the host state actually signed it. Look at the status here. Spain and Estonia are active signatories. So, an Estonian company hiring a remote worker in Spain, perfectly fine. But if that same Estonian company hires someone in Latvia, a non-signatory, the whole framework breaks down. The old rules apply, meaning anything over 25% remote work triggers local tax liability. You absolutely have to check that signatory list. All right, Section 4, navigating non-EU bottlenecks. Because if you are outside the EU, the rules change entirely. Let's look at bilateral agreements, and specifically a massive bottleneck for U.S. employers. Spain has this highly popular digital nomad visa. But to get it, a foreign remote worker needs a certificate of coverage from their home country to prove they're paying social taxes there. The problem? The United States Social Security Administration has consistently refused to issue these for voluntary telework. They strictly interpret the 1988 totalization agreement to only cover employer-initiated formal corporate transfers. And without that certificate, the Spanish consulate will straight up reject the visa application. Because of this U.S. roadblock, employers are forced into some tough operational trade-offs. You could register for direct payroll in Spain, but let's be real, that means paying full Spanish social contributions, slapping an extra 30 to 35% on top of the gross salary. You could use an employer of record, an EOR, but then you're paying third-party management fees. Or the worker becomes an independent contractor, an autónomo, but that throws the entire heavy tax burden directly onto the individual. None of these are perfect. They are all pretty serious compromises. Section 5, the direct registration fallback. So what happens if the A1 or your bilateral treaties fail? How do you employ someone directly in Spain without the sheer agony of setting up a full local corporate subsidiary? Well, you use the fallback, registering as a non-resident employer or NRE. It's basically a three-step dance. Step 1, obtain a Spanish tax ID, a NIF type N, from the tax agency. Step 2, register as an employer with the General Treasury of Social Security to get your contribution account code. And finally, Step 3, enroll the actual employee using Form TA.2/S. But don't let the simplicity of those 3 steps fool you. Step 1 requires some heavy paperwork. You can't just fill out a quick web form. You are going to need your corporate articles stamped with a Hague apostille. You need sworn certified Spanish translations, you need a notarized power of attorney, and you have to formally designate a local Spanish fiscal representative to handle any audits. Setting all of this up, usually through a local agency or gestoria, requires significant upfront time and setup costs. Which brings us to Section 6, essential timelines and costs. Let's ground this whole explainer in the hard realities of 2026 compliance. The absolute most crucial takeaway here is that Spanish labor inspectors do not mess around with deadlines. You can submit the initial worker registration up to 60 days prior, but, and this is absolutely critical, the active affiliation must be finalized before the very first hour of work actually commences. If you drop the ball, fail to register them in time, and get audited, you aren't just paying retroactively. You are looking at severe financial penalties and a disastrous 20% interest surcharge on unpaid amounts. And let's talk about the costs, because they are definitely rising. In 2026, structural escalations are hitting employers right in the wallet. On top of that total base contribution of around 31%, Spain has bumped up the EMI, the Intergenerational Equity Mechanism pension levy, to 0.75% for employers. Plus, if you're deploying highly compensated talent, there's a new progressive solidarity tax kicking in on salaries that exceed the maximum contribution base. That adds up to 1.46% at the top bracket. One quick final warning before we wrap up. Beware the permanent establishment trap. Employing a remote back office worker in Spain is generally fine. But if you deploy a senior executive or, say, a sales specialist with contract signing authority, the tax authorities might decide you've essentially created a corporate footprint in Spain. And just like that, your foreign enterprise could suddenly be on the hook for Spanish corporate income tax. It is a massive risk. So I will leave you with this to chew on as you audit your own 2026 setup. Is your cross-border remote work policy truly a powerful talent magnet? Or without the right A1 certificates, NRE registrations, and tight telework tracking, is it a €1 million compliance trap just waiting to spring? Make sure you check those treaty lists, respect that 49.99% limit, and whatever you do, finalize your registrations before that very first hour of work. Thanks for tuning into this explainer.